again, the renewed arguments of the state for the consciousness of guilt. In our position is that it was 16 times that it was referenced in the trial.
Counsel, you said something in brief I thought was really interesting. You said, and this is unique because there was a mandate for the second DCA telling everyone what happened incorrectly in the first trial. And you said in your brief, the second DCA gave them an explicit instruction and they declined, the state did not follow it, and therefore that, you seem to say that should bolster your argument that it's a fundamental error. And I certainly see why that bolsters your argument that the state prosecutor is culpable. I mean, the errors here were clear and obvious. But are there any cases that say, I didn't find any, that say the fundamental errors analysis should turn or in part be hinged on the fact that somebody had explicit instructions ahead of time from an appellate court? I didn't see a case where, in every other case I saw, it was the nature of the error, not the level of culpability of the person making the error, or the level of knowledge they have, I'd say intent, right?
Yes, sir. Thank you. I understand the question. We would definitely point out that the prohibition against prosecutorial misconduct is something that the state is aware of and has been. It's very important because retrying these cases is very expensive, and we're potentially looking at hopefully a third try at it. The error itself, with the arguments about consciousness of guilt, we feel that those dig deep enough into the case to provide a fundamental error, because that itself goes towards, in order for the jury to believe that.
So you're saying the error itself, not the level of intent. Is that the answer to my question? Then no, that the level, there's no authority to support the proposition from the level of intent. And the fact that the state was warned by an appellate court beforehand in any way factors in the fundamental error analysis.
I don't have any case law that says it does. So that's just something that we wanted to point out to the court. While the state was well aware that it shouldn't happen, but it did happen, it seems the court is aware of that. So if the jury believed that Mr. Alford did not return because he knew that he was being looked for by the police, then that goes directly against our theory of the defense, and the state should not have been able to provide that argument without the nexus between his leaving and the crime itself. So it seems that the state was able to provide that nexus, it would be a proper argument. But since it goes directly towards the theory of the defense, that our position, that makes it even, that is why it becomes a fundamental error. The state is arguing that Mr. Alford had consciousness of guilt, and that's why he left. And so if the jury believes that he left because he was being looked for by the police, or that he was wanted for this crime, or that he was actually there, the state arguing that consciousness of guilt goes directly, not only does it point towards him being guilty, but it goes directly against our theory of defense, which is the opposite, which is that he didn't commit a crime because he simply was not there. So the state could argue the consciousness of guilt if they were able to provide a nexus between the crime and the leaving, but they're not able to. So them arguing that against our theory of defense would be fundamental error, because it would be impossible for the jury to make a finding of the merits without that argument by the state.
But in this case, counsel, isn't it true that the evidence that arguably provided a basis for the state to even argue that was admitted without objection, unlike the first trial, which was actually, wasn't that really the holding of the second DCA, is that the admission of the evidence was error. And so therefore, and then in dicta, they said, oh, by the way, we also find improper prosecutorial argument. Wasn't that really what the second DCA held and sort of added?
It is, Your Honor. So they had it under the less stringent standard of harmless error.
Right, the state had to prove that beyond a reasonable doubt, the erroneous admission of the evidence didn't contribute to the verdict. And that's why it got reversed, as it should have been. But here, different standard burdens on your part, right?
Yes, it is, Judge, yes, it is. And so we're arguing that the admission of that evidence without an objection, of course, that evidence being provided to the jury denied Mr. Alford a fair trial and due process, because that would have tainted the jury's understanding of the evidence to the point where he wasn't making a fair trial.
But on appeal, the admission of the evidence isn't actually challenged, is it? I thought the entire argument was based on improper closing argument, or argument only. This was the actual admission of the evidence challenge on the fundamental error?
Well, I know that in the first trial, Mr. Alford testified to a lot of this information, conversations about, or testimony about going to Pennsylvania, et cetera. And he did not testify in the new trial.
Right, but they played an audio recording.
Yes, sir. So that evidence was admitted into the new trial, which we also believe is error. Because it's essentially the same trial that happened again.
Yeah, so that's the second error you raised here. It wasn't in your briefs. You didn't raise any admission of evidence there in your briefs. It was all argument.
Right, that was my question, is on appeal today, certainly understand that you fully briefed the issue of fundamental error and argument by the state. But I don't recall an argument of fundamental error because of an erroneous admission of any evidence about him moving or anything else. Or am I missing something? I guess Judge Wise as well.
Well, you're on our appeal, you're right, it did go towards the admission of the state's 16 pronouncements of consciousness of guilt, along with, and then the second point on appeal would have to do with the golden rule violations and whether or not they were submitted.
During the state's argument?
Yes, sir.
Correct. Okay. That's my understanding. All right, thank you.
All right, thank you, Judge. Any other questions?
Oh, no, I didn't even have to sit down. I was just saying thank you for responding to my question.
And then cumulatively, there's fundamental error with the admissions of the consciousness of guilt. And then when we move into point 2, which has to do with the golden rule violations, it seems like a few of those were admitted by the state, by the appellee, and their rebuttal, their response, admitted that these were not proper. Some of them, it was not admitted that they were not proper, but our arguments still are improper. Taking even just into account the ones that the appellee admitted are improper, when you combine those with the consciousness of guilt arguments, collectively, it's so extensive that the influence pervades the trial, gravely impairing a calm and dispassionate consideration of the evidence of merits by the jury. So part 2, when it's coupled with part 1.
Counsel, I'd like you to respond to something in that brief. One of the things you said in your brief is that they asked the jury to picture themselves in the place of the victim, essentially by saying, they said, the prosecutor said, picture the scene, see what she looked like in that bed, but picture how she would have looked like on the porch, and she would have looked on the porch in the condition, how she stopped talking, how much pain she would be in, nobody can imagine that. And what the state said in their brief was, well, they opened the door to that by, mentioning the fact that that the victim didn't initially identify the defendant, said something else. And to me, the thing I thought was interesting about that, it's not like she was mumbling and it was hard to tell what she said, and therefore her ability to speak was an issue. She said something completely different than what the defendant's name, right? What she said and her ability to talk was not an issue at all. So to say that the defendant opened the door to talking about that by pointing out a misidentification, that didn't line up for me. What's your response to that?
Well, I agree with your view on that, Your Honor. I was just trying to find where that was mentioned in the brief. The victim's ability to speak would not require the jury to have a feeling and understanding of pain that she was in. And so I would feel that is an improper argument by the appellee, that it doesn't go towards any understanding of the actual evidence as that was stated. It seems clear from reading the testimony that it was given by her that she said the name, and she also said something that rhymed with the name, but it was not the name. The appellee's mention of her being in pain is only offered to incite sympathy.
Our jurors specifically instructed they are not to consider sympathy in rendering the verdict.
Yes, Your Honor.
And so, are you asking us to make an assumption that the jury disregarded that instruction, disregarded the trial judge's instruction, both at the beginning of the case and at the end, that what the lawyers say is not evidence, it's not the law, you're to follow the law on what I instruct you?
Yes, sir. The jury's only human, and you can't unring the bell to know it's wrong. It's like if I said, try not to think of a green lizard, the first thing that comes to your mind is a green lizard. Even if I tell you to stop thinking about it, you're still going to be thinking about it. So this information is given to the jury. Apparently it was not objected to. And the judge said everything that Your Honor just said. But that does not prevent the human aspect of the jury to continue to consider this information. Did they go back into the deliberation room and map it out and write on the dry erase boards things that the state said that we think are improper? Maybe not, but they had already heard it, it had already gone into their minds, and it brought back to the deliberation room.
Well, and if you could just assume that the jury, that those things never had an effect, then the appellate courts would never be able to overturn any verdict based on appeals to sympathy and closing argument.
I'm sorry, Judge, can you ask me that?
The fact that appellate courts do overturn verdicts based on, golden rule violations and appeals to sympathy and closing arguments establishes that we don't merely rely on the instructions and say no matter what the prosecutor does, it's okay. Correct?
Yes, sir.
Are judges human?
Yes, they are.
And do judges hear and see the same things that the jury sees?
If the court's asking me if something is presented in the courtroom, does it appear different to the judge as it does to the jury? I believe it would, yes, sir.
So the judges see the same evidence, hear the same testimony, look at the same photos, videos, hear the same arguments. And yet, is there a single case where if an improper argument by the state is made, somehow that allows a challenge to the judge's sentence because the judge are only human and they had to be persuaded by that to some extent and set aside their obligation under the law and impose the sentence based on sympathy?
Sometimes, yes, Your Honor. The jury is not going to hear and see things the way that a judge would, or an attorney, or others of us who are somewhat inured to hearing these sorts of terrible things. And I believe on a case-by-case basis, it is something that the court should go back and give it a try for.
Counsel, I know you're in rebuttal time, but I think there's a question I want to say.
The judge can do that sentencing once the jury who hasn't heard those things is being guilty, correct?
I'm sorry.
A judge can only render that sentence once a jury that has not heard those improper things has rendered guilty, correct? The judge may have heard things that the jury can't hear or isn't supposed to hear, and then go on to make a sentence. But the judge cannot do that until after the jury who has not heard those improper things has rendered a guilty verdict, correct?
Yes.
Are you aware of any case where in a bench trial, an improper argument has been a basis to reverse the judge's decision in a bench trial where there is no jury?
I don't have any cases that nature. But I believe I'm out of time.
Yeah, well, you still have time for rebuttal, but stop.
Thank you.
Thank you. Good morning, Your Honors. I'm Taylor Shell from the Office of the Attorney General on behalf of the appellee, the state of Florida. Counsel, may it please the court. This is not a case of misidentification. This is not a case of a lack in evidence. This is not a case where the prosecutor argued flight from Florida as consciousness of guilt, which was the reason why the Second District Court of Appeal reversed the appellant's first trial. This is a case where the errors that appellant alleges were met without objection and are thus not preserved for appellate review short of a showing of fundamental error. This is not a case of fundamental error. The record does not reflect that the prosecutor's comments reached down into the heart of the trial and yielded a reasonable probability that the jury found the appellant guilty based on those comments.
So can you respond to the same argument I asked about? I thought it was interesting, right? Normally, when we're looking at a prosecutor's error, we don't have an appellate court having said to a prosecutor ahead of time, this is impermissible, don't do this. So I certainly think the argument is strong, at least the prosecutor's culpability, his or her personal culpability is higher when they were instructed ahead of time, don't do this, and they did it anyways. It's unique that we have that in making the fundamental error analysis. I don't know any cases that we can't take into account. I don't know any cases dealt with the issue. So it seems to me that there was a level of intent here, or at least knowledge. How should that factor in? I don't think there's any cases that it shouldn't.
Sure.
Or that it should.
I would respectfully disagree. I think that the first trial and this trial were two very different trials. You have the first trial where defense counsel filed a motion in limine trying to prevent the introduction of the evidence from Florida to Philadelphia. You have that motion in limine that is denied. You then have the renewed objections during trial. And that flight from Florida to Pennsylvania is introduced not only through the appellant, but through a number of other individuals in the first trial. That's not what occurred here. What occurred here is that the state does mention a number of different times that the appellant left for the last time. However, that's in response to appellant's theory of defense that he could not have been there. He left between 9 and 10 with Ms. Bartholomew, and so thus he could not have been at the scene.
Yeah, but counsel, you would respond to, first of all, the issue in the first case, the relevant point was not that he was in Pennsylvania, it's that he was left Florida, right? So it was the leaving that is the key thing. And that was present in this case too. He left this apartment, he never went back. And, you know, if his theory of the case was I wasn't there, then it would seem the way to rebut that was to say, yes, you were, right? Not to repeatedly harp on the fact, hey, he was worried about being stuck here with the car, he left. He never went back to the scene. What a big coincidence that was. And I think the language your client used was, he doesn't know what's going to happen. He doesn't want to be left there with a car. It's a split-second decision when he leaves. When I think the only evidence in the record at that point as to why he left was that they had planned to leave before the crime happened.
And I respectfully disagree with Your Honor on that. The evidence was that Ms. Bartholomew planned to leave with her child at about 10 p.m., 5-year-old girl. She kept trying to go back inside the house. He kept shutting the door. Or she kept trying to go outside of the house. He kept shutting the door, telling her to go back inside. Her testimony on the record is that it wasn't his original plan to leave with her. It was his original plan to stay there. That's why all of a sudden at 10 o'clock at night, he's asking her for a ride. And you have that whole dialogue. Can I go to Sebring? Can I go to my mom's house, etc. So the prosecutor is commenting on the change in plans, not just flight. Additionally, consciousness of guilt in flight is never argued in the second trial. The Second District Court of Appeal reversed the first trial because there was consciousness of guilt argued based on the flight without that sufficient nexus. You don't have that here because you're just arguing that the evidence reflects that he was there at the time that he said he was there.
So what do you say to the prosecutor's statement? He says, take me away from here so when you're gone, I'm not here with no car. He doesn't know what's going to happen. As if he's aware of some investigation and is afraid of what's going to happen with it. That seems to me to clearly implied connection between him wanting to leave and the fact that investigation is going on, that's consciousness of guilt.
Again, Your Honor, I believe that the prosecutor was responding unartfully to the idea that he was changing his plans and leaving for the evening, that he was never coming back, that despite the fact that he wanted to stay there that evening up until the time when Ms. Bartholomew got in her car, that changing plans was relevant and what needed to be discussed. I don't see the same consciousness of guilt argument that the court does.
You said he made that, so take what you're saying is right? He made a change in plans and wanted to leave. You're saying they opened the door by saying he wasn't there. The rebut that he wasn't there was he was there, right?
Yes.
And what the prosecutor said was the opposite of that he wasn't there, he left. And he used this language implying he left for a specific reason, and he didn't know what's going to happen. The only thing that could refer to was the investigation. And then the prosecutor says it 16 times. So to say that they was rebutting the defense argument that he wasn't there by harping on this, how you rebut that is to say he was there. That's not what happened here. It was not rebutting the defense's argument, right? It was saying something completely different than what you would say to rebut the defense's argument. It's implying it's because of the investigation and saying it 16 times.
Yes, Your Honor. I maintain that the state's position is that he is responding to what was introduced in opening by defense counsel and what was then introduced in testimony by Lisa Bartholomew, saying that was a change in plans, that connection happened. And again, we don't ask for perfect cases. I wish we had perfect cases, but we don't have perfect cases. What we ask for is due process, and due process was had here.
And counsel, I could follow up because I'm trying to understand it. I think the term inartful is maybe generous. But it's somewhat of a confusing argument that the prosecutor makes. Are you saying that you read that argument as being that the prosecutor was arguing in response to the defense that he wasn't there, that yes, he was there, and then after he did what the state alleged he did, he was still there, and now he's making plans to leave?
My argument, Your Honor, is that he was there. He was there. He wanted to make a change of plans, and that's when he left. Not because he left because he was guilty. I don't read the arguments that way. I could certainly see how the court would see it with the repetition. I believe that the prosecutor is simply responding to that theory of defense that was brought out not only in opening statements, but throughout the trial through different witnesses.
None of the response was about him still being there. I mean, you say, I explained why it doesn't seem like it could possibly rebut the defense's statement or opening argument, and your response was, I still maintain that it does. That's not addressing the substance of the issue. You rebut some defense's argument that they weren't there by showing that they were, okay? That's not what the prosecutor did. He spent a significant time in oral argument talking about the fact that the guy had chose to leave. That has nothing to do with establishing that he was still there, and implied that it had to do with him making a decision based on the investigation. Those two things, like when you're saying we maintain that this was in response, that makes no sense to me, because it just flat out does not rebut in any way what the defense said in their opening statement.
I think if you look in context at the closing statement, it does make more sense. You have where, and like the court said, inartfully it might be generous, but you have where somebody's consistently saying that can't possibly be true. And based on the reflection of the first trial, it appears that they're trying to argue. I read it as more of the argument is so preposterous, the defense theory is so preposterous that it couldn't possibly make sense. And the repetition is certainly not ideal, but I don't think that actually means that they're arguing consciousness of guilt. I just think it's poor argumentation.
Can you respond to the speech issue? So, They say in their brief that the appeals to the condition of the victim were an improper appeal for sympathy. You said in your brief, well, they put that at issue by pointing out the misidentification. And to me, if if they had said, misidentification was because she couldn't speak well, we weren't sure we heard the right word, we weren't sure she had an ability to speak, then yes, that would put her condition and her ability to speak at issue. Here, what she said and her ability to speak is undisputed. Everybody knows what she said, and it was something different than the defendant's name, right?
I disagree with that, Your Honor.
Okay, go ahead.
Detective Kendrick, or Deputy Kendrick's testimony was very clear that she was in a great deal of pain. She had a very tough time speaking. She had her throat slashed from here to here. She's bleeding out. She's in and out of consciousness. She's been on the porch for an hour and a half trying to beg for help. I don't believe that it is uncontroverted that she had an ability to speak or didn't have an ability to speak. My understanding based on the record is that she had a tough time speaking to anybody that was on that porch, and that she identified Trigger or the appellant to everybody other than Deputy Kendrick. And so if we look at the closing argument in context, if I may, it's on page 595 or 539. The prosecutor says, and one other thing before we move on to Sandra's testimony, former Deputy Kendrick said, he went down, he's there, he's a canine, he's just there to assist. He bends down, Sandra's in really bad shape, and he says, what happened? Who did this? And according to him, she says, and he kind of tried, and then you have the alleged golden rule violation that we maintain is not in fact a golden rule violation. I mean, listening to her talk on the stand, trying to picture how she would have sounded, even talking and how much pain she would have been in. And that's the same for the other golden rule violations. She uses, so they're responding. It was kind of implied that she uses a racial slur that then later she changes her story to Trigger. I think in context, it's specifically saying she had a tough time talking because she had her throat slashed and she couldn't speak.
I don't dispute she had a tough time talking, but what she said was not an issue, right? And people's ability to understand the words she said and her ability to get people to understand them. There's no dispute about the words that she said. So why do you put an issue by bringing up a misidentification? You seem to say, well, they opened it up by bringing up misidentification, and therefore this argument was proper because it goes to her ability to speak. But I don't dispute the fact that she was in a lot of pain and might have had difficulty speaking, but that did not end up being an issue because there's no dispute about the words that she said. You see my point? If there was a dispute about the words that she said, then her ability to convey the words would be an issue. But ultimately, there's no dispute about the words she said. Everybody agrees on the words she said. That's undisputed. So when the words she says are undisputed and it's something other than the identification of the defendant, it's not a response to the misidentification saying, well, she had trouble talking when her throat was very normal.
I don't know if I agree with the court that it's undisputed what she said. I think that the main point was that Deputy Kendrick had a hard time hearing what she said. It's what he interpreted her saying. I believe that she indicated in her testimony that she said Trigger and not a word that rhymes with it. And Deputy Kendrick is the one that she said that he heard the other word. And that's what's at issue, not what she said, but what he heard and why he would have heard something different than everybody else. So it's important that the prosecutor was trying to highlight, this is what she said, and if he heard something different, then that's a different situation. She had blood coming out of her throat, etc. But I don't think it's uncontroverted whether she said that one word to Deputy Kendrick or not. I think that was the crux of the argument and defense theory throughout trial.
Wasn't there also an either implicit or expressed argument that she may have been trying to protect somebody else?
Yes, Your Honor. So there was an argument that her son, who had some mental health issues and was 19 years old, she was actually out looking for him when the attack occurred and was communicating with the appellant about whether he had seen her son. Defense argument was that she initially said to Deputy Kendrick the word that rhymes with Trigger, and then was covering up the attack by her son who had mental health problems, and that's why she changed her story from Trigger, from another individual to Trigger. That made more sense, and that she didn't want to get her son in trouble. She didn't want him to get arrested. So that was an additional defense theory that the prosecution was responding to.
And so if that's wasn't that also part of the context that there was a response to the victim's ability to formulate this plan to cover somebody else
Yes,
while she's in this pain and et cetera?
yes, yes. To require a new trial, the comments must deprive the defendant of fairness and impartiality, materially contribute to the conviction, or be so harmful or fundamentally tainted that reversal is required. That cannot be said in this case. First, the state fairly commented on the evidence that conflicted with appellant's promise during opening. Second, the alleged golden rule violations were not in fact violations when taken in context. Appellant's conviction is based on DNA on the cooler and the door handle, multiple identifications by the victim.
Yeah, I don't think anybody questioned the amount of evidence in the case. It's just the fact that you have overwhelming evidence. That's not how we look at fundamental error. You can have overwhelming evidence. The issue was whether there was error. I don't think anybody's saying there was a lot of evidence.
Sure.
It's the issue of whether there was an error.
And counsel, let me ask, I said that your description of the article was generous, and I think my description of generous is more generous. As a trial judge, there's some of these things the state attorney just crossed the boundary, and with an objection, I would have sustained it. So when something like that happens, I understand what the appellant's remedy is, new trial. But how do we, as an appellate court, we're looking at what lawyers are doing, not just lawyers for the state, whose obligation is to follow the law, give over Brady material. It's not about doing whatever you can to win it, right? So, in a case where Judge Mize points out, I think it was dicta, but nevertheless, it came from an appellate court. Don't do this. And a state attorney does it. That's troubling to me. So how would you soothe my troubled mind?
How would I soothe your troubled mind about?
What are we to do? Are we to affirm, but maybe drop footnotes, or, the felon's asking us to reverse? Sort of like, under Fourth Amendment. So the society might pay a consequence, perhaps, because of law enforcement's improper conduct. We're going to exclude the evidence, judicially created. Judicially created remedy to enforce fundamental constitutional right. And so now we have something where improper arguments are being made by an attorney to this jury. They're considering things other than the evidence in the law to render a verdict. That's a serious matter. So what's your what do you think we do? Just PCA it and just do nothing, leave that to the bar for the state attorney if they cross the boundary?
I would never
It's a
presume.
good question. Do we know what happened? Do we know if anything happened as a prosecutor?
I'm not aware. I would never presume to tell the court what to do. I certainly
I'm asking
understand.
you to make your argument of why we should reverse and if we should do anything else.
Sure.
Or why we should not reverse. What's different, say, than a Fourth Amendment violation, exclusionary rule sort of analogy?
Absolutely. So the first thing I would say is that you would not be able to reverse absent a showing of fundamental error. So the court would have to find that all of these comments, which we have argued most of them are not in fact impermissible, but all of these comments taken together are in fact fundamental error, have reached down into the heart of the jury and caused them to passionately consider the evidence as opposed to dispassionately consider it. I think that there's no fundamental error here, so I don't believe that this court could reverse and find fundamental error. However, the court does want to, if the court does want to send a message, the court certainly has the ability to write an opinion sending that message. I just think that you don't have enough for reversal here because of the fact that you've got no fundamental error.
How do we ask your opposing counsel this question? It's like, okay, we have to find the jury disregarded the law. How do we do that? What's the framework? How would we write the opinion that says, what does this mean when we're talking about reach down? What is the tipping point where this is out of bounds? Is it sort of like, well, you know when you see it? I mean, because if we're going to say something about it, if we're going to reverse fundamental error, we want to help lawyers and parties know what are the bounds, what are the boundaries? Otherwise, everything's just sort of ad hoc.
Sure.
And we are past time, but I'll let you go.
Thank you so much. I would just ask the court to take a look at the cases that appellant cited, Cardona and Rodriguez. I think those are jarring and shocking examples of prosecutorial misconduct that even when looked at in a fundamental analysis are so gross that they need to be reversed. I don't believe that any of the comments that were present within this particular case rose to that level, and thus, because they don't rise to that level, there's no fundamental error here. And we would request that the court deny appellant's request for relief and affirm the judgment and sentence of appellant.
That's the one that's pretty good. Do you agree with them that if we find fundamental error, we don't do a harmless error review? If it's fundamental, we don't determine whether it was harmless.
I mean, obviously, there are different standards of review. I kind of do that analysis in my brief, both of those analyses. So, yeah, I think that.
When you say it was harmful, basically, I say, well, the evidence is overwhelming, but to me, that's really a harmless error, and apply a harmless error analysis, right?
Correct.
But they cite cases, and I don't see anywhere where they're incorrect, and say, if it's a fundamental error, it doesn't matter if it's harmless. Doesn't matter if you got the guy on video and DNA and this, it's a fundamental error, you reverse, whether it was harmless or not.
If I could cite a case for the court to look at that states that error that is harmless cannot be fundamental, and that is Kraft v. State, 312, Southern 3rd, 4546, out of the Florida Supreme Court in 2020. And our position is that if you do have that analysis, error that is harmless cannot in fact be fundamental. Thank you. Any other questions for the court?
Thank you so much.
Thank you.
Thank you, Judge. So our position, again, there's no credible argument that this was not consciousness of guilt with the statements made by the state so many times.
Counsel, before I lose you, because I see your hand with light, let me ask you the same question. Is it just, we know when we see it? Are you going to point me to your cases? Can you sort of articulate how we would write it, of why this is fundamental error? Are you seeing this case as being, this is really a cumulative error case, or is one of your points or two of your points that tips the scale? How would we articulate it?
I think, Your Honor, it's one of the points specifically is fundamental, and then also cumulatively, both of them are. What's the one? One would be the first one, Your Honor, with the consciousness of guilt. The reach down argument there is like I tried to say before, is the argument of the consciousness of guilt specifically and directly opposes the theory of the defense. And the consciousness of guilt was not an appropriate argument because the state was not able to provide any sort of nexus. So taking that illegal argument and directing it specifically at the theory of the defense is improper and creates fundamental error. That's the answer to that.
Counsel, you have extra time. I'm probably supposed to long, but you got a couple more minutes. So go ahead.
Okay, thank you, Judge. So with the golden rule violation, we would say, again, we just would be referring to the words that are, the state, or the appellee put them in bold. I point to it in a second one, on page 43 of their answer brief, is D. Nobody can even imagine what she felt like, the pain she was lying in on that floor. And the argument in support of the state's position was that was simply a comment on the evidence and the severity of the injuries. But I don't want to belabor the point, but it's literally talking about not being able to imagine the pain, the severity of the injuries could have been established with medical records or some other. So there's the golden rule arguments, we believe, without belaboring the point, just clear on the records.
But counsel, don't they specifically, I mean, it seems to me that this whole bit about the consciousness of guilt, the golden rule violation, excuse me, in relation to the comments that the prosecutor made about the condition that she's in, it's identification. Was she identifying her son, or was she identifying Trigger? Who was she identifying? And at one point, the prosecutor says, if she's covering for her son, at that time she's in that condition, horrible condition, what we can imagine, what she felt like, the pain lying on that floor when she's lying there. Her thought is, my son did this, I don't want to get my son in trouble. I understand how you could take that to be a golden rule violation, but I could also just as easily see that from the state's perspective. No, the prosecutor's just really trying to emphasize here with her condition that maybe she didn't articulate exactly as she wanted to in response to that.
I would say that the state should have articulated their argument in a different fashion. She simply chose a different word instead of essentially asking the jury to imagine the pain that she was in. I think that I understand what the court is saying. I believe that the state just chose the wrong words to fashion their argument, and therefore made a golden rule violation doing that.
In other words, it's what you do that's the violation, not what you were trying to do.
Yes, sir.
Is that what you're trying to say?
Yes, I don't, well,
You can have a permissible purpose, but if you commit a golden rule violation in the context of trying to achieve that purpose, it's still a golden rule violation.
yes, Your Honor. I absolutely agree with that, and I'm not saying the state wasn't trying to do a golden rule argument. For all we know, they were trying to slip it in somehow. Yes, Your Honor. And then in response to the state, to the appellee rather, saying that.
And counsel, at this point in time is up, but I'm going to let you finish what you're going to say.
Yes, sir. Thank you. And this goes back to the consciousness of guilt, whether he left or was he. And the defense's argument was preposterous because in their position, they could prove that he was there, and he's saying that he wasn't there. The way to do that, and I think the court touched on this, is just by offering other evidence, in fact, that he was there, instead of tying consciousness of guilt argument together by repeatedly dropping in that he never came back, that he never came back, that he never came back. Not just that he left, but the argument that he never came back ties in the sort of temporal loop that is in the statute that's establishing that he left in order to not come back, in order to escape prosecution, which is not
On the next case, case 23-151, Costello versus State of Florida.
Good morning, Your Honors. Connor Mark on behalf of the appellant Ryan Costello.
Counsel, you want to get to it? If I proceed, I just going to come on to the stand. Are you going to argue from there?
I can argue for the lecture.
It might be helpful because this is broadcast on YouTube, so your microphone's up there. at the stand. And counsel, did you want to reserve any time for rebuttal?
Yes, Your Honor, I would request 5 minutes for rebuttal.
Okay.
Please the court, counsel. Connor Martin again for the record on behalf of the appellant Ryan Costello. Your Honors, we are here today appealing the denial of the appellant's motion for post-conviction relief. I'd like to begin by giving a brief factual recitation of the case as it proceeded through the system, including a procedural history. In March of 2013, the appellant was tried in Lee County, Florida, associated with lowercase tribunal number 10 CF 17525. He was represented by trial counsel Mr. Wilbur C. Smith III, Esquire, and as second chair, Mr. Ryan Doyle, Esquire. In the state's amended information filed in July of 2011, the appellant was charged with having committed the following offenses: Count 1, second-degree murder; Counts 2, 3, and 4, child neglect; and Count 5, tampering with evidence. At the conclusion of trial on March 6, 2013, the jury returned a verdict finding the appellant guilty of manslaughter, the lesser included to the second-degree murder charge, and a guilty verdict. Yes, Your Honor.
Counsel, we're in court. I'm looking at, so we're not bound by the courts other than the Supreme Court. I'm looking at 3.850. It gives grounds upon which you can file a post-conviction motion. And then I'm looking at section B, and it says the motion to vacate a sentence that exceeds the limits provided by law may be filed at any time. The motion to correct sentence, you can give up. No other motion shall be filed or considered pursuant to this rule filed more than 2 years after the judgment and sentence become final, unless it alleges certain things, none of which are an issue here. To rule for your client, nobody just have to go outside the rule. I'm not saying the courts might not have done that, but we're not bound by them. I do feel bound by the rules, unless I feel bound by the rules of the Supreme Court. And it seems to be a rule for your client, we've got to ignore the rule.
Well, Your Honor, what we're really asking is for a correction of the sentence. The proper maximum exposure for the appellant would have been 15 years under the conviction of the simple manslaughter. It wasn't until the state had requested and the trial court granted the introduction of special interrogatories to the jury that allowed them to find the elements of aggravated manslaughter.
But counsel, your argument is this is an illegal sentence?
My argument, Your Honor, is that the fundamental error occurred in allowing the jury to be submitted those special interrogatories that allowed it to find uncharged conduct.
You see any fundamental error exception in 3.850?
I'm sorry?
You see any fundamental error exception in 3.850?
No, Your Honor, I do not.
So we have to, in order to rule for you then, we have to ignore the rules.
I think I'm going to fall short of making an equity argument here. The court may have to step outside the bounds of the rule, but based on the egregious substantive due process violation, I believe it's proper to do so.
What authority do we have as an appellate court to step outside of the rule promulgated by the Florida Supreme Court?
Your Honor, I would have to submit a supplemental brief on that issue. I don't have any case laws to that effect. Right.
Because there is no case law that says we can violate rules. You expect, if you go back to your office, do you expect to find case law that says appellate courts can violate rules promulgated by the Supreme Court?
Your Honor, I may be able to find case law that states with such an egregious violation, the time limits may be not adhered to as strictly. I believe it's possible, and I would be willing to search. What the appellant's argument is that this case involves such a significant violation of due process rights because the appellant was deprived of his fundamental right to liberty in being convicted of uncharged conduct, taking his maximum exposure from 15 years to 30 years, which the court did indeed sentence him to. This fundamental error can be raised at the post-conviction level because it is fundamental in nature. The trial court had...
But I'm sorry, counsel, I just want to make sure, just to be clear, That's only if we can go outside the rule, the time limit of the rule.
I think what you're trying to say is some other DCAs have gone outside the rule and want you to do the same thing. So I'm summing up.
That does.
You can just say it.
Yes, Your Honor, I would ask the court to go outside the rule as has been done by other DCAs.
Do the other DCAs also go outside the statute that the legislature has enacted? 924.051.
Your Honor, I would have to research that issue, but I can submit a brief on that issue if the court would allow me to do so.
Well, let's just talk about the statute for a moment. In subsection 5 of 924.051, sub 5 says collateral review is not available. This is regardless of when it's filed. It's not available on grounds that were or could have been raised at trial and if properly preserved on direct appeal of the conviction and sentence.
May I respond?
Yes. So here you agree that this could have been raised at trial. In fact, I think you believe it was raised at trial.
It was raised at trial. I don't believe that it was properly preserved, and the trial court, in the order denying post-conviction motion, found as much as well, that it was not properly preserved. Thus, it was not available to be briefed on direct appeal. However, it did not rise to the level of ineffective assistance of counsel. So it became kind of a procedural bar where there is no remedy for the appellant.
Well, if it wasn't preserved, I looked at it, I think it was sufficiently preserved. I think he could have argued preserved on appeal. I think he would have, I don't know, I'm saying he would have won every issue with it. I think he would have established it was preserved. If it was not preserved, he still could have appealed it as on direct appeal as fundamental error, correct? That is within the statute and the rule, that if it's not preserved, you can still appeal it on fundamental error grounds on direct appeal if your client can do that either, right?
That is correct, Your Honor, but he's not confined to having made that the fundamental error argument on direct appeal only. It could also be raised on a motion for post-conviction.
Within 2 years under the rule, right?
That is correct, Your Honor. Your Honors, the state has conceded at the evidentiary hearing on the appellant's motion for post-conviction relief that he was convicted of uncharged conduct. That, I submit, rises to the level of fundamental error because it allowed the increase in sentence to double from his maximum exposure of 15 years to the simple manslaughter. It was a completely new crime that he was convicted of, and the defense was on no notice of it. The first that it was ever brought up was at the charge conference, just prior to instructing the jury. So there was a lack of notice, and it would have changed. Counsel testified at the evidentiary hearing, both Mr. Smith and Mr. Costello, Mr. Smith and Mr. Doyle had testified that they were primarily concerned with defending against the second-degree murder charge. If they would have known that aggravated manslaughter of a child, a first-degree felony, would have been on the table at some point, they would have changed their trial strategy.
Let me ask you about that because, the information didn't allege his age. I don't think you have to allege the exact age. It alleged he was a child. And obviously, there was no way for your client to dispute he was a child. It's not like your client would have had a defense to say the child wasn't a child. It's not like there was an issue as to whether the child was on the cusp of 18. Right? He was clearly a child. So the only thing I can think where this would have made a difference to your client in terms of preparing a defense was this caregiver portion. But that's not actually in the statute. So what exactly is the allegation that your client would have done something different? Had your client been aware in advance of this?
Well, trial counsel had testified, both Mr. Doyle and Mr. Smith, at the evidentiary hearing, that they would have taken a more aggressive approach to defeating the culpable negligence. So they were primarily focused with showing that there was no malice or ill will toward the deceased on behalf of the appellant.
Counsel, why would they use, I'm sorry, go ahead, answer Judge Lyons' question. I apologize, go ahead.
Council would have taken a more aggressive approach to defeating the culpable negligence that was alleged as part of the aggravated manslaughter of a child. Trial counsel knew that this was not a murder case, but they did believe that it was quite possible due to the facts and the
The
introduction.
culpable negligence, that's part of just the manslaughter, and the manslaughter was a lesser included, right?
Yes.
It wasn't improper, and you don't assert it was improper for manslaughter to be included, it's just not aggravated manslaughter. And manslaughter did include culpable negligence. So
Yes.
that's not an error for them to have to be able to deal with culpable negligence, because that was properly included as a lesser included offense, wasn't it?
It was properly included as a lesser included, Your Honor.
Okay, so how could that be something they would have done different if this error had occurred?
Well, they knew that the jury would want to hold somebody responsible for the death of this child. So not to allege that they had almost phoned it in on the.
Yeah, the way I read that was that we knew the jury might go for manslaughter.
Yes.
And what you're saying to me is, what you just said is, if they knew it would have been aggravated manslaughter, they would have put more effort into disputing culpable negligence. But the culpable negligence part wasn't a surprise, because that's part of both manslaughter and aggravated manslaughter. And manslaughter was properly included, nobody disputes that.
Nobody disputes that was a proper lesser included, Your Honor, correct in saying that. Trial counsel's testimony at the evidentiary hearing was, we would have prepared differently. This was an ambush. It was never discussed in plea negotiations. It was for the first time in the charge
But
conference.
what specifically would have been done differently? I asked you once, and you said culpable negligence, but culpable negligence, that part wasn't a surprise. So that doesn't really show me they would have prepared differently. What specifically would they have done differently?
I believe that they would have defended the culpable negligence more aggressively and put more stake into disputing that, the culpable negligence, because it would have been a more severe offense. So if they believed that it was likely that the jury would find for the manslaughter, based on his exposure, if he would have had aggravated manslaughter of a child, that would have allowed for a conviction of 30 years, they would have taken more of their defense centered around that culpable negligence.
So the assertion here is that culpable negligence was that issue, and they knew that, and that was fair game. But with it being a 15-year sentence, they wouldn't try as hard as they could. But with it being a 30-year sentence, they would try as hard as they could to defeat it.
I believe that they would have structured the defense differently, and that was their testimony. It was a fundamental error because it was uncharged conduct. And I understand what Your Honor is saying, that, they are effectively on notice because,
Not effectively, completely unnoticed. It was 100% proper to include manslaughter.
of course,
It's just not aggravated manslaughter.
that is correct, Your Honor. Yes, and so I submit to the court that, I can't go back and take testimony again from the evidentiary hearing or from trial counsel, but they had made the statement that they were patently surprised and they would have structured their defense differently. And in discussing it with trial counsel, they would have taken a more aggressive approach to the culpable negligence due to the exposure of the aggravated manslaughter. That was the statements, those were the statements elicited at the evidentiary hearing. I can't beyond that get inside the mind of trial counsel.
Which is why you have an evidentiary hearing, because we can't go back to the evidentiary hearing either. And isn't your client under 3850, assuming we're disregarding the Supreme Court rule on timing, and we get to the rule itself, isn't the burden on your client to prove prejudice, which means prove what its counsel would have been done differently? Not in generalities of we would have been more aggressive. Isn't it higher burden than that? What actually would you have done that you didn't do, weren't able to do because of the surprise, a different witness, a different request for documents, a subpoena, something? Is there any, other than what you've articulated, I think you've articulated well how scant the testimony was below. Does that meet the burden?
Your Honor, I believe it does because of what the result is, what the result reaches. And that's an additional 15 years of this man's life in
Yeah,
prison.
well, that doesn't answer the question. The question was, don't you have to show more specifically what you would have done differently? That was the question. And the answer to that question is either no or yes. And here's the specifics from the record, or there are no specifics from the record. Answer the question he asked.
Yes, Your Honor.
Don't you have to show something more specifically the trial counsel would have done differently?
Indeed, you do have to state with specificity why the result would have been different. So to answer the question, you have to provide something specific. A more aggressive approach to that element of culpable negligence seems general, but several strategies could have been employed.
We have the key, could have, there's a lot of sentence in that word when you have to write law.
So we're into rebuttal time. But we should finish your response to that
So
question.
it could have, there's a lot of work in that sentence when you're under standard, when you have to identify the specifics, right?
Yes, Your Honor. And the most that I can provide is that they would have structured their defense differently. That was the testimony that was elicited in the hearing.
Thank you.
Good afternoon, Your Honors. Good afternoon. My name is Natalia Reina, and I represent the state of Florida in these proceedings. May I please the court? Your Honors, at the core of appellant's brief is the question of whether he can overcome a procedural bar that was caused by the actions or inactions of his own counsel at the post-conviction level by couching his claim as a fundamental error claim. And the short answer to that question, Your Honor, is that he cannot. And there are two main reasons for it. The first one is that a claim of fundamental error is not one of the grounds established in Rule 3850 to grant post-conviction relief. And the second one
Hold
is
on,
that-
counsel. Well, I mean, one of the grounds is just any judgment in violation of the Constitution, right? That could be a lot of things. Fundamental error could certainly fall into that, right? I mean,
Yes, Your Honor.
You have a right under the Constitution to only be convicted of charged conduct, don't you?
Yes, Your Honor.
Okay,
And
so,
yes, and the question, and maybe, or not maybe, what we have here is his claim fits perfectly within that rule. But when you look at the whole procedural rule, you have to look at the whole procedural rule. And there is a specific, very clear in the face of the rule that you cannot bring this claim if you have not raised that claim during trial or direct appeal. And that's the problem that he is facing here. And to go around that problem, he is using the concept of fundamental error, which I believe which we submit does not apply in this case. And I want to start by recognizing that the landscape surrounding the the concept of post-conviction of fundamental error is not clear. It is applied at different stages, it's applied to different results. But substantively, there is at least agreement among the courts that it means an error that goes to the essence of the trial, an error that a conviction could not be occurred if not because of that error. And the courts have said this is an error that is not necessarily applicable to a party, it's an error that goes to the essence of the justice system. Now, that concept has been applied during direct appeal. But here we are talking about post-conviction relief. And at this stage, we have to think about fundamental error in comparison with the principle of finality of cases. So at this point, I believe the principle of fundamental error should not be used to go around a procedural bar that was caused by the own actions and inactions of counsel in this case. Now, Your Honor, it's not just that they didn't preserve the claim, they waived the claim during trial and during direct appeal. Trial counsel raised the issue before the court and said, you know what, you are giving me aggravated manslaughter as an enhancement, but I don't think the elements that you are providing in the jury instructions go with the statute. So he was not really arguing about where not giving aggravated manslaughter as an enhancement. He was just arguing what elements of the aggravated manslaughter should go into the jury instructions. That's a different argument of what they have here. Now, even if you accept that fundamental error could be used to go around in this case, to go around the procedural bar in this case, we don't have a fundamental error here. What you have is rather than a conviction based on an uncharged crime, what you have here is a conviction on a permissive lesser included offense. And on the Ray versus state.
Well, I asked them, what's fundamental error included, and they said no. So, I'll ask you the same question. Fundamental error is not in 3.850, is it?
It is not. It is not the text of the statute.
You can attack under 3.850, any judgment imposed in violation of constitutional laws of the United States or the state of Florida, correct?
Yes, you are. The problem here is that you don't have a judgment or conviction in violation of the Constitution of the laws of the state of
All right,
Florida.
fair enough, but that has nothing to do with fundamental error, does it? I mean, what you're basically saying is, I mean, you're kind of asking us to inject something in the rule like they did, only on the opposite side. Fundamental error does not appear in 3.850.
Exactly, you know, what I'm saying is that his claim is a claim that fits within that specific ground in Rule 3850. What apparently is trying to do is go around that by using the concept of fundamental error. That concept doesn't apply here. Now, when we go back to analyze the statute, we don't have a conviction that is in violation of the laws of Florida. Why? Because he was not convicted of an uncharged crime. He was convicted on a permissive lesser included offense. And even though that permissive inclusive offense was not named in the indictment, the Florida Supreme Court has stated in Ray versus State that is not fundamental error when there has been some action by trial counsel that is accepting that course of action or accepting those instructions.
What did he do in this,
That's
what
what
did the defendant do in this case? The way I read Ray's second prong is that I had to take advantage of it in some way, right? Use it to his benefit, indicating that was a strategic decision, right? Like if you're a defendant and you get some lesser charge included, maybe you think that makes it more likely the jury lets you off on a more serious charge, right? So a defendant may benefit from a lesser charge. And the way I read that second prong of Ray is, if it looks like it was a strategic decision to use it to the defendant's benefit, the defendant can't then later complain about it. Here, defendant objected, defendant didn't use it, defendant didn't try to benefit from it, defendant said at trial, judge, this is wrong, don't do this.
Well, yes and no. Yes, he said, you know what, I think this is wrong. He said that. I think it is why. Because the elements of aggravated manslaughter, as they are given in the instruction, do not exist in the text of the statute. When you look at aggravated manslaughter, it is simply the death of a child by culpable negligence. That's it. Those are the elements. So if that crime would have been included in the indictment, those are the only two elements that are essential to be included, right? But what happened here is that the jury instructions added some kind of elements, specifically the caregiver element. So when the defense counsel look at it, says, okay, there are more elements that you have to prove under the jury instruction. So I guess that makes the case more difficult for the state to prove. And that was what he was taking advantage
So
of.
when you add that element, so when you have an element that's not an element within the original charges, it requires to prove additional facts, and the sentence is higher, does that make it not a permissive lesser included offense?
No, in this case, it's a judge under the schedule of permissive lesser included offenses to a crime of second-degree murder, aggravated manslaughter, or charges. So based on the schedule of the jury instructions, that is what happened here. Besides, you know, in the indictment, they
Yeah, but that's based on the, I guess, the correct elements for aggravated manslaughter. Here, there was another element included that, albeit was incorrect, right? It should have been included, it wasn't in the statute caregiver, but nonetheless, that element was not in the original charges, this caregiver element.
and that is true, Your Honor, but it's an element that was found beyond reasonable doubt by the jury.
But it wasn't charged.
It wasn't
Well, you have a
charged,
right
but
to
it
charge
wasn't,
him,
it really, to be honest, to be able to find him guilty of aggravated manslaughter, in this case, they didn't need it. Because if you follow the text of the manslaughter statute, the only thing that is asked there is for the child and the culpable negligence element. So yes, they added an element there. What defense counsel said is, okay, you are adding that element, it is going to be more difficult for you to prove your case. That's what he did there. He accepted that because he benefited.
But he didn't accept it, he objected and said, don't do this.
Yes, but the court, Your Honor, when you read the transcript, the court told him, so what is the prejudice here? Show me what is the prejudice. And he didn't continue to his
But
objection.
nothing about Ray says that the person had to, if they don't keep objecting after the judge has ruled, that means they've taken advantage of it. The second prong of Ray speaks to taking advantage of it, using it to the defendant's benefit. And just objecting but not continuing to object after the judge has overruled your objection is not the same as taking advantage of the benefit.
But the judge asked him, show me, I will consider it if you show me how the prejudice occurred in this case, but proving an extra element. And he said, no, that's my objection, Your Honor. That's how the transcript reads.
Okay, so that's what you just said is not taking a benefit. It's finishing your legal argument.
Or it's a waiver, Your Honor. It is a waiver.
So making your argument and then the judge rules against you, that means you've waived your argument.
He is not necessarily, the judge gave him the opportunity to clarify what was the prejudice there. And he said,
The judge said, do you have anything else? And he said, no, that's the full extent of my argument. He didn't say, and therefore I withdraw my objection. He said, I've made my argument, Judge, that's all I've got. What's the ruling?
well, Your Honor, I will disagree in the sense that he specifically.
I was a trial. If I ruled and a lawyer said, like, I said, I've heard your argument, I'm ruling, I wouldn't let the lawyer keep going.
Your Honor, but also the defense trial said, you know what, that's not up to me, I don't have to prove that. So he was, in the whole context, he considered the error, he wasn't really clear about the error, so he continued the objection, and at the end of the day, he said, okay, you are giving me more elements to prove that, you understand more elements to prove that is not a prejudice to me, and that is not a prejudice to me. Besides, Your Honor, the issue here is, when we look at Petel, the case that said that aggravated manslaughter is not an enhancement to the crime. In the brief, they said that this was the error in the instruction to give the aggravated manslaughter. But he wasn't really fighting to give, during trial, to give the aggravated manslaughter as an enhancement. That was not the fight. The fight was over the elements of the aggravated manslaughter. So I would say that's an additional situation there that was why they waived that case.
And counsel, as far, I don't recall in the transcript, the argument about the jury instruction, but was there actually ever an objection to the trial judge that, Judge, my objection is not just to perform the instruction, but my client being charged for something that's not in the information? I don't recall that argument actually being made.
Your Honor, my recollection, that was never said.
Okay.
The issue was whether the elements of aggravated manslaughter, as they were going to be given to the jury, followed the manslaughter statute or not.
Okay. And then, how do you think the first prong of Ray affects this case? Does that help you or hurt you?
Your Honor, what we have here again is a conviction. It is not really a conviction because he was convicted of manslaughter. It was an adjudication on a crime that is lesser in penalty to second-degree murder, and lesser offense to second-degree murder that was the crime charged in the indictment. And we are not looking at manslaughter, we have to look at the crime that was charged in the indictment according to Ray. So I think both of those prongs are established in this case.
So even if you fail in the second prong of Ray, you still believe we can affirm based on the first prong of Ray? Because aggravated manslaughter of a child is an F1 punishable by 30 years as opposed to first-degree felony punishable by life and second-degree murder. Higher in degree, punishable by life. Lower in degree, just a first-degree felony, or arguably the same degree, and then 30-year maximum.
I do agree with that.
Okay.
But Your Honor, if you were find that Ray does not, that this case doesn't meet the elements or the prongs in Ray, this is still not fundamental error. Still, it's not a way to go around a procedural bar, not at the post-conviction level when the principle of finality of justice takes a different dimension that it would have taken during direct appeal. And there are some cases that in general say that substantive due process violations can be raised at any time. But there are many other cases from the Florida Supreme Court that says that post-conviction relief is not an opportunity to argue with things that should have been brought directly during direct appeal. So the problem is that you have a concept that has been applied different in different states, and the courts have come out with different results. So it's a confusing, to some extent, concept. But at this time, at this point in time, he is barred for bringing this claim. Now, Your Honor, adjudication and sentence for aggravated manslaughter, a crime that is not a permissive lesser included offense to the crime charge, is not a fundamental error, but rather is a trial error that should have been brought to the attention of the court during direct and direct appeal. And there is a difference between trial errors and fundamental errors. Fundamental errors, if I may use one of the cases that is cited here, Holly Walker versus State. In that case, they took out different cases that represent what fundamental error is. And in those cases, they are talking about, for example, convictions on crimes that didn't exist, convictions in which you have a statute that is unconstitutional, convictions in which you have double jeopardy. So are convictions in which the trial, in essence, should have never happened. There are structural errors. It's very different to errors like a jury instruction that needs to be presented before the trial judge for him to resolve. So we don't have, that is not the type of error that we have here. In conclusion, Your Honor, a motion for post-conviction relief is not an opportunity to present for the first time a claim of trial error that could have been brought to the attention of the court contemporaneously or during appeal. And couching a claim of trial error that should have been brought to the attention of the court during trial of direct appeal is not a way to go around of this procedural act. For this reason, Your Honor, we request that the conviction be affirmed.
Your Honor, as argued previously, this is the proper forum. The post-conviction motion is the proper forum to allege fundamental error for the first time. There are a handful of cases that cites this proposition, some of which were not cited in the appellant's brief. I would like to provide those citations to the court at this time. The first would be Hip v. State, 650 Southern 2nd, 91, out of the 4th District Court of Appeals. The next is Willie v. State, 600 Southern 2nd, 479, out of the 1st District Court of Appeals. And finally, Loggins v. State, 204 Southern 3rd, 982, out of the 5th District Court of Appeals. So as to opposing counsel's claim that this is the improper forum to have brought the fundamental error claim in a post-conviction motion, that is simply incorrect. The trial court made the same error, the trial court that presided over the evidentiary hearing when issuing the trial court's order. The trial court had an erroneous reading of the Hughes case and believed that it stood for the proposition that if not brought upon direct appeal, then it could not later be raised in a post-conviction motion. That is simply untrue, as cited by the cases that I have stated and cases cited in the appellant's brief.
How do those cases resolve the issue of 3.850 stating that they cannot be used to address matters that could have been raised or should have been raised at trial or on appeal?
Well, Your Honor, if I may quote directly from the Hip case, their opinion reads, notwithstanding the language of 3.850, an error which amounts to a denial of due process can be raised for the first time in a post-conviction proceeding. That's cited to Wiley v. State, And the cases that I've cited on the record, a lot of them are string cites to one another. So they are all kind of referring to each other.
Do they address that subsection of the statute from the policymaking branch of our government, 924.051, sub 5?
I think what he's saying is that language, notwithstanding the language of the rule, is really problematic for us. Notwithstanding what the 50s, notwithstanding what the fourth DCA did.
Yes, sir. Well, it's been the fourth DCA as well as the first DCA in Willie, BC, and then the fourth district, both in Hip and in the, I'm sorry, I was referring to the Halberton case. So just the fourth and the first DCA that have arrived at that interpretation.
Well, it seems when they're interpreting the rule, it seems like they're saying, notwithstanding the language, that means they're not interpreting the rule, they're just saying, we're going to create an exception to the rule. That's different than interpreting the rule.
That is a fair reading of the opinion, Your Honor. That's a fair statement. I'm sorry, I misspoke. That's a fair characterization.
Do those cases address Ray?
Ray is cited throughout the opinions. I believe it's the Halberton case that addresses Ray. And Your Honor,
Sorry, counsel, what was the name of that case?
that's going to be Halberton v. State, 7 Southern 3rd, 601, out of the 4th District Court of Appeals.
7 Southern 3rd, 601.
601, correct, Your Honor. Yes, out of the 4th District.
And how did the 4th District distinguish Ray in the Halberton case?
I can read directly from the opinion for Your Honor. It reads, unlike the situation in Ray and Bedford, Halberton's trial counsel objected to the instructions and the issue was preserved and actually argued on appeal. The law at the time when the direct appeal was less clear and this court affirmed. So it makes reference to Ray in that it distinguishes Ray from the Halberton case in and of itself. Because
What was the issue in Halberton? Was it uncharged conduct?
the primary issue is instructing the jury, yes, on uncharged conduct, or allowing them to find an enhancement or an improper, I'm going to refrain from using the word enhancement because that's not what occurred in Halberton and it's not what occurred here. It was a completely separate offense that the jury was permitted to find. And I see that I'm nearly out of time here. If I may just wrap up briefly.
No.
The appellant was convicted of uncharged conduct. That's been conceded by the state, and I submit to this court that it results in a fundamental error. Such an error was in violation of the appellant's substantive due process rights. I couldn't think of something that would be more of a problem or more of a violation of substantive due process rights than being sentenced to an additional 15 years in prison beyond what one should have been legally permitted to be sentenced to. The appellant concedes the jury verdict of manslaughter. That's the appropriate lesser to the second-degree murder, of course. That has been proven, but the appellant respectfully requests that this court issue a written opinion instructing the trial court to strike the aggravated manslaughter conviction, substitute a manslaughter conviction, and resentence him based on that new score sheet. Thank you.
Thank you, counsel. Thank you so much for your presentation. Thank you. Thank you.